Our three branches of government, executive, legislative, and judicial, administer our democratic, civil, and legal rights. The California Constitution declares that all people are by nature free and independent and have inalienable rights. Among these are enjoying and defending life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining safety, happiness, and privacy. Article 6 of the California Constitution vests the judicial power of the state in the Supreme Court, Courts of Appeal, and Superior Courts to interpret the law and to protect those inalienable rights. Since 1905, the California Courts of Appeal, as the intermediate courts of review, have ensured that the law is interpreted and applied consistently and uniformly in the trial courts. During their long history, the Courts of Appeal have presided over the expansion of legal theory and have set volumes of precedent to guide the deliberations of the justices, producing a body of law that protects the rights of all Californians while advancing the administration of justice. Beyond the bench in the black robes, the justices are ordinary people, women and men from diverse ethnic, cultural, and economic backgrounds. But many have led extraordinary lives, witnessed extraordinary events, and overcome extraordinary challenges. And through their commitment to public service, they have contributed to the evolution of both our state and our nation. The California Appellate Court Legacy Project is an archive of interviews with retired state justices. The interviews weave a rich tapestry of the events, large and small, that shape the judicial branch of government. The personal stories of individuals as law students, lawyers, judges, and justices make the ideals they represent real. They also shed light on what shapes individuals to embrace a career in the law, either by chance or design, and what motivates them to public service. From dramatic historic events like the Great Depression and World War II, to gradual changes in social mores and how the justice system works, the justices deal with topics covering racism and sexism, judicial independence, and the role of the law in a democracy. Here are some excerpts from their stories and the times, institutions, and issues they illuminate.
My first vivid recollection of childhood is standing in a line with my sister and a couple of my brothers and my dad around the courthouse, I think it was, in Denver. I was about 8 years old, 7, 8 years old, where that was a relief line for shoes. We had no water, no heat, electricity at home. We had no food. Dad didn't have a job. We'd planted rutabagas and tomatoes out in the backyard and potatoes to try to get something to grow. It was scary, an anxious time. I remember at school you'd have planning for what happened if there were bombings. You'd sit, and so there were drills, bomb drills and things of that sort. Rationing of food, rationing of gasoline.
One thing that probably, if you've talked to other former infantrymen or Marines, we don't usually talk about what happened on the battlefield. It's painful, and we lost close friends. I was given a promotion by my captain from PFC to staff sergeant because of casualties. So at the age of 19, I had a group of 12 men under my care and responsibility.
With the exception of two Ninth Circuit judges of Chinese ancestry, Thomas Tang and Hiram Fong of the Ninth Circuit, I may have been the only state appellate judge appointed at that time who was Chinese American. I don't know if there's anybody outside of Hawaii in the 50 states who had that position before me.
At that time, it was very difficult for people who belonged to minorities to get into the big law firms. There weren't any Hispanics, there weren't any blacks in the big firms or the middle firms.
From a very personal standpoint, as a black woman, I'm very conscious of the fact that the playing field has been evened very much over what it was 100 years ago. And the integration of the court, not only the jurors, but the justices, the lawyers, and at every level of the court now, you can look around and see someone who has a face like yours.
At the time that I was going to law school, there were less than 10 women in my law school class. So it was a very different type of environment than what I see with law students now. And so we even actually had one of my professors, which this is something you would never get away with now. He used to have what he'd call Ladies' Day. He'd just come in and say, it's Ladies' Day, and he'd only call on the women that day.
And I finally had to haul him up and say, listen, one more reference to the court as anything other than Your Honor, and you will be held in contempt, because this is a court. It doesn't make any difference who is sitting here as a judge, but it is the court, and it has to have your respect.
In putting the growers together with the production people and the farm labor people and what have you, and got the bill to the governor's office. I'll never forget that negotiation. But the Agricultural Labor Relations Act became law, and it's the first act in the country, frankly, on labor relations.
And I said, Governor, number one, I'm a Republican, and number two, I don't agree with a lot of your political positions. And while you are vehemently opposed to capital punishment, I am not opposed to capital punishment. And he said, I'm not selecting you for your political views. I'm selecting you because I think you would give me honest legal advice.
Different types of law require different kinds of lawyers. And then when you get to like the appellate level, then you add another complexity, and that is the ability to write, because it's surprising that although some people can think clearly enough, they can't write clearly.
You pretty much became a sort of professional jack of all trades. The opportunities to specialize were there, but they were very limited. And when you're in the small town, you're really in the role of a general practitioner. I probably spent 2/3 of my professional time on civil matters, probate, domestic relations, some corporate work, and then criminal cases, largely misdemeanors, and occasionally a felony or two.
And then I froze. And I stood there thinking, God, what am I supposed to do next? And Judge Curler, who was a very sympathetic man, had known me for years since I was a kid, looked down and he said, counsel may present the will now. Oh, that's what I'm supposed to do. So I've always remembered that when I was a judge, that when young lawyers froze and needed some help, do it in such a way that it looks like it was their idea. Save their face with their client. So that was a good lesson.
We have to have a method for correcting error. And without in any way disparaging the trial courts, you cannot have the largest trial court in the world and the most litigious society and not have error as a consequence in some cases.
A great deal of the law in California is actually made by the Court of Appeal. If it's important and trend-setting, the Supreme Court inevitably will pick up on it and expand upon it and speak to it.
You must not be ideologically stiff. You must be open-minded And I think that you should, to the very best of your ability, put out of your mind any preconceived ideas.
I feel very strongly about dissents. Not an ego trip. Is there a way of working out the problem? Is there another solution to the problem? I feel very strongly that dissents are, unless you feel very strongly they shouldn't be there, because the party should think there's a unanimous decision by a court.
I'm a firm believer in the separation of powers. I think that has to be, I would jealously guard that as best I could as a judge. Even though I would disagree with the legislative opinion, if it's not subject to a constitutional attack, it's legally justified.
It's a very simple judicial philosophy. It's fairness, bottom line fairness. If the court system is a system of laws, the rule of law has to prevail. None of us is, quotes, an activist.
I've kind of watched this changing atmosphere of greater and greater scrutiny. And I think it's good. Overall, it's good. I think that judges are held to a very high standard, and that standard has to be enforced.
My great-grandfather was a judge back in Illinois, and he wrote something at the end when he retired, and I read that recently. I was very impressed with it. And basically what he focused on more than anything else was how important it was to our system to maintain the independence of the courts, to do everything we possibly can to get good people on the courts who are independent of however the wind is blowing at a particular time.
The courts of appeal are the backbone of the justice system in California, because without a system which afforded meaningful review, it wouldn't be much of a justice system. And that's the function and the office of the Court of Appeal.
Through their stories, anecdotes, and reflections, these individuals share their personal experiences and insights. They reflect moments in time that connect with the history of our state and our nation, and they shed light on the evolution of our courts, our society, and our democratic system of government. We are grateful for their candor and their perspectives in these interviews. And most of all, we are grateful for their public service to the judicial branch, the courts, and the people of California. We hope their stories will inform, educate, and inspire.